Hey all, welcome back. Want to start part 2 here of our lecture series for this week. Like I said, I'm going to make this a little bit shorter than the last one so you don't have too much content to cover, but it is important that we sort of wrap up or bring together our unit on negligence here. And typically I do this by talking about the different negligence applications. So we've looked at negligence from the perspective of the plaintiff, right? These are the 4 elements that you have to prove in a negligence claim. We've also now looked at negligence from the perspective of the defendant, looking at the possible defenses available to them if they are sued for negligence. And the only thing we haven't talked about is the actual application of negligence. So what are the situations where plaintiffs actually file negligence claims against a K&R organization? And that's what I want to cover here in our last unit. So basically, we're going to cover 4 different categories of negligence applications, as you can see listed here on the slide. I'm going to take them one at a time, try to give you some context and a couple of examples that I'm going to upload onto ReggieNet, and hopefully this will bring everything together for you and prepare us for our next in-class meeting where you're actually going to be able to assess a waiver, but also respond to some questions regarding actual application of a negligence claim. Okay, so our first application here is negligent supervision. Unfortunately, in our field, this one is pretty common, right? Where we've got situations where basically there's been a failure to provide necessary supervision or monitoring to an event or activity, which has then resulted in some kind of injury to our participant. Again, our field involves a lot of physical activity, so we know that supervision is important. Unfortunately, there are situations where there is negligence and someone has been injured. So our goal as practitioners is make sure that we are providing the appropriate level of supervision to all activities that we put on or provide. So you might be thinking, how do we know what level of supervision is required? Well, basically, when we think about negligence supervision in the context of our field, we want to think about 2 things. One, we want to think about the quality of supervision that we're providing, and 2, we want to think about the quantity of supervision. So on one hand, thinking about, are the people that we're putting in places of supervision properly certified and trained to provide that supervision? Do they have the proper licenses to do this? That's quality, right? And then quantity is, are there the appropriate number of supervisors given the nature of the activity, the risk level, the participants involved? So there are a number of factors we want to look at here when determining what that number is or what that supervision looks like. Unfortunately, there's no magic formula here to determine how many supervisors we need and what level of supervision. But we can consider these factors, and hopefully that will help us determine what appropriate supervision looks like. So risk and danger level. As I'm sure you can assume, activities that incur more risk or higher levels of danger are going to require a higher level of supervision, right? Both from a quality standpoint, but also a quantity standpoint. Facility space. So the type of space we're utilizing is going to dictate the type of supervision we can provide, right? So a larger, more open space, particularly if it's outdoors, is going to limit the amount of supervision we can provide, right? Where a smaller classroom size space might be a little bit more manageable. The type of participant we have in terms of their expertise or level of skill is important. So someone who is new at an activity, a novice, who's not done the thing before, is going to require a different level of supervision than, say, someone who's an expert and does have experience doing this particular activity before. I'm going to refer to one of the examples I uploaded on ReggieNet here involving a young man and his family's lawsuit against Bridgeview Park District. So this was a case where this young man had signed up for the swimming program in the summer with Bridgeview Park District. They had done, a skill assessment earlier in the week and found that this young man did not have a very high level of skill when it came to swimming. He was still learning, but despite that, they had him swimming in the deep end with some of the other kids who had a higher level of skill, and unfortunately, he ended up drowning and dying. And so, as you can see here in the headline, his family was successful in suing the park district for negligence, because really they weren't providing the proper level of supervision, given that he was a novice and didn't have the level of skill that warranted him even being in that end of the pool, let alone not having proper supervision. So, kind of a stark example of how things can go wrong pretty quickly if proper supervision isn't administered. The same is true with minor versus adult, right? So just as we want to provide higher level of supervision with a novice, we also want to provide a higher level of supervision with children, people under the age of 18. I think that one kind of goes without saying. Okay, so when we think about supervision, we can sort of categorize it into these two categories, right? Providing general supervision, providing specific supervision. So as you can imagine, general supervision is applied basically when we've got a low risk activity, a group setting, so maybe a large number of people, and then typically some kind of large space or facility. In some cases could be an outdoor space, right? So in general supervision, you feel comfortable having maybe a handful of supervisors available for a large group of people, assuming it's a low risk activity in a large space. Something like a marathon is a great example of an event that probably only needs general supervision, right? We can't possibly expect to have specific supervision for thousands of people that show up to one of our running events. So the idea that we might have a handful of supervisors on staff at various points throughout the race is reasonable given the size and scope of that activity. Where on the other hand, specific supervision we're going to use when we do have those more high-risk activities, where we are able to work maybe one-on-one with individuals or small groups. And typically we want controlled space for these situations. So I think the best example of this is like a rock climbing situation, right? We've got a fairly high-risk activity that if someone were to fall could result in a pretty big injury. So high-risk activity, generally rock climbing is a one-on-one situation where you have the rock climber and belayer below. And generally these are controlled spaces, right? Either outdoors or in some kind of rock climbing facility. So that's a situation where we could find it reasonable to provide specific supervision. Okay, so like I said, when it comes to providing supervision, there's no magic formula to determine, the quality or quantity, but it's important to consider these different factors, right? If we consider these different factors, then we should be able to make good decisions about the level of supervision we're providing. Okay, another common type of negligence in our field is negligent medical care. So we can think of negligent medical care basically from two different perspectives. One, prevention, and the other, reaction. Obviously, we want to be preventing any kind of medical emergencies in our facilities or at our events, right? So that means preventative health care. Maybe having proper screening in place. So if we have a youth football league, we want to make sure that we are utilizing good concussion protocols so that we're screening to make sure that people don't continue to participate in an activity despite having a concussion. That would be an example. Making sure that we have proper emergency planning in place in case something does go wrong. So making sure folks are properly trained to react in some kind of medical emergency. So that's the prevention side of things we can do to try to prevent a medical emergency from happening. Sometimes we're not going to be able to avoid it, right? So we're going to actually have to provide emergency medical care to participants, to members, etc. So first and foremost, we want to make sure we have qualified people to assist, either at the site or able to come to the site in a quick manner. Making sure that we can get proper medical care to our site is really important. If you've been to an ISU football game, you've probably seen there's always an ambulance parked in one of the corners of the field. That's them making sure they're able to get proper medical care provided to any player that maybe goes down or anyone in the stands who requires that care. So those are things you have to think about in terms of being able to react and provide medical care. I'll give you an example of a case where, a K&R site was not able to provide proper medical care. Barth versus Board of Education in the city of Chicago. This was a really unfortunate case involving a young man who was injured in a PE class in the city of Chicago. Unfortunately, he was just sent to the nurse's office where he had to wait for, I think it was a couple of hours before the nurse even saw him. And in that time, had swelling in his brain and suffered long-term brain trauma because of this delay. So basically, the school was not able to provide him proper medical care, and that resulted in some pretty lifelong damages for him. And his family was able to sue the city successfully and get several millions of dollars through that lawsuit. Okay, one other thing I want to mention here in terms of negligent medical care that's a concern, particularly for those maybe wanting to get on the coaching side of things or physical education side of things, this concept of fraudulent concealment. Basically, if some kind of physician or team official or trainer even has medical information about a player or athlete and they fail to provide that information to that individual, they can be sued for fraudulent concealment. So basically, they're withholding important medical information that could certainly lead to further injury. So this is obviously concerning as we think about all of the concussion-related issues, from very young age through all the way up to the NFL. And this idea of people not being provided with all of the information to make an educated decision about their own health. So, of course, if you're ever in a position to hold medical information about a participant or athlete, you definitely want to provide that information to them. Withholding that information could lead to a very serious lawsuit. Okay. Switching gears a little bit here, another area where we see negligence claims is on the employment side of things. So basically, we have two employment torts, negligent hiring and negligent retention. So negligent hiring occurs basically when someone has failed or breached their duty to hire competent employees. Right? So this idea that someone didn't do proper background checks in the hiring process, they didn't call references in order to check in on what this employee was like at a previous organization. Negligent hiring can lead to injury to your customers, to your participants. So it's really important that when you're in a hiring position that you're doing your due diligence, you're making those phone calls, you're running background checks, you're completing drug tests, you're doing all those things to make sure that the people you're hiring and giving contact to your customers are, people that you can trust to do the right thing. So negligent hiring is definitely a concern, but one that can be easily avoided if you're taking those proper steps. The other employment tort that is important for us to consider is negligent retention. So basically, this occurs after you've hired someone, in some cases long after you've hired them, where basically the employer is aware that they have an employee who is, doing things incorrectly. They've done things repeatedly after you telling them not to do them. They continue to do those things, and you take no action to either discipline them or discharge them. You retain them in a way that is negligent because you know that they're not doing their job properly, but you keep them on, and therefore that is a risk for your customers and other employees. So the case of Ryan Harper that we looked at last week at the fitness center, this was a case of negligent retention, right? The manager knew that Ryan was showing up late to work repeatedly, and that this was, putting a risk for their members that were coming into the fitness center. So Failing to do anything about it, really firing Ryan is what he should have done, or disciplined him so that his behavior changed, and he failed to do either of those things, right? So when Will Jenkins files that lawsuit, not only can he argue that the space was unsafe and therefore the fitness center was negligent in providing a safe environment, he could also argue that there was negligent retention here, right? That this employee shouldn't even have been on staff. The company knew they were a risk and continued to keep them on anyway. So negligent retention is also a concern. So making sure that you're properly supervising employees is a way to avoid negligent retention. Okay, I did upload another case to ReggieNet for you to check out if you're interested in. This case is from a few years ago. It involved a coach at Rutgers University. It was Mike Rice is the coach's name. So this is the men's basketball coach at Rutgers. Basically, if you watch the video footage, which I made available on ReggieNet, he had been physically assaulting players for years by basically throwing balls at them, throwing baskets at them, basically pushing them in some cases. And there was video evidence of this that was provided to the athletic director at Rutgers. And the athletic director and the president of the university had this information and yet failed to take any action against Rice for a long time. So some of the players that were involved in this lawsuit were specifically claiming negligent retention on the behalf of the athletic director and the president, right? Basically, they knew this guy was a danger to their student athletes, but failed to do anything about it when they probably should have either disciplined him or fired him knowing this information. So check out that article if you're interested in learning more about that case. Okay, last application I want to talk about here is what we know as premises liability. So the idea here is that as practitioners, it's our job to provide a safe environment to our patrons, right? If we fail to provide a safe environment to our patrons, we can be sued in a premises liability claim. So the idea here is that, as K&R practitioners, we're often operating in a facility. That facility has to be safe for the people who are using it, not just the facility itself, but the equipment at the facility as well. So making sure we're providing a safe environment, and if we're doing that, then we can probably avoid a premises liability claim. Okay, in order to assess a premises liability lawsuit, we have to understand something. We have to basically understand that there are different levels of duty owed to participants based on the type of participant that they are. So basically, we have three different types of participant in a premises liability case. So invitees are owed what we call the highest level of care in a premises liability case, meaning that there are some high expectations to provide a safe environment for people that are considered to be invitees. So what makes someone an invitee? Well, someone's an invitee if they provide some kind of economic benefit to the facility owner or operator, okay? So what does that mean? Well, if we have a sports league that we are operating at a park district and that person participating is paying some kind of fee to participate, they would be considered an invitee, right? Because they're providing some kind of economic benefit to the facility owner. Because of that, we owe them the highest level of care. What does that mean? That means that we are going out of our way to make sure that space is safe. We are doing regular inspections to find or pinpoint anything that is unsafe, and then we're fixing those problems. Basically, we're going above and beyond to make sure this person is safe. Now, that level of duty only applies to what we call the area of invitation, meaning that basically we're only providing safe environment in areas where people are allowed to be, right? So if you go to an ISU basketball game, areas of invitation for you as a patron are certainly the seating bowl, the concourse where you can walk, the concessions, the bathrooms, all of that is area of invitation, right? So as practitioners that are working at Redbird Arena, we would owe all invitees, a level of care to keep that area safe. Now, if you decided you wanted to run down onto onto the court during a game, that would no longer be a part of the area of invitation, right? So you wouldn't be owed that same level of care. Okay, so invitee we know is owed the highest level of care in a negligence claim. A licensee is the second level of care here. So a licensee is someone who has permission to use someone else's premises, but only for their own benefit. They're not providing any kind of economic benefit to the owner. So for instance, let's say that you have a friend that has a pool at their house. Your friend invites you over to swim in the pool. They owe you some level of care to warn you of different hazards that you might incur while you're swimming in the pool, but they do not owe you the same level of care that an invitee is owed, right? Because you're not providing any kind of economic benefit to them as the homeowner. So a licensee still owed some level of care in that you're owed some kind of warning if there are hazards, but they don't have to go out of their way to seek out potential harms or fix potential risks. It's not quite the same level of care. Finally, this last category of users is a trespasser. As you can imagine, this is someone who enters a premises without permission of the operator. And as you can, I'm sure you can imagine, this particular category of person is not owed very much protection, right? Basically, if you're somewhere illegally, there's a small level of care that is owed to you because essentially you're breaking the law. So basically, as the landowner or facility owner in those cases, the only duty you have is to try to refrain from inflicting injury against that person. You call the police, get them there to take care of it. Generally speaking, you do not owe them any other level of care like you do a licensee or an invitee. Okay, just wanted to give you more of a visual chart of what I just explained on the last slide. So again, I think for our purposes in K&R, we have to think about the fact that oftentimes we are going to be dealing with invitees, right? People that are providing some kind of economic benefit to us as facility owners, facility managers. So because of that, we owe them a high level of care, right? We need to provide a safe environment for them. And that doesn't just mean, doing a regular safety check. That means consistently monitoring our premises, making sure we're making proper updates to that facility, following proper procedures with those facility updates, that we're following any legal requirements that are out there that are new. Anything we can do to keep participants safe, we need to be doing for those invitees. I did add one other article to RegGNet this week for you to read. This one shows us an example of an invitee suing a K&R facility. So this occurred last season in the NFL. You had a fan who was at Miami Dolphins game, sitting at a bar in the facility, and while he was sitting there getting a drink, a piece of the bar itself fell on his foot, and actually one of his toes had to be amputated because of this. He filing a lawsuit against the Miami Dolphins, basically claiming, hey, they didn't provide a safe environment while I was there, which led to this injury. So he should have a pretty successful case against them. I think it's still in court right now, but it's pretty hard to argue that, right? He was an invitee. He was providing some level of economic benefit to the Dolphins by paying for a ticket. So they owed him a high level of care to keep him safe from harm. By having this bar fall apart and fall on his foot, they failed in that duty. So they are likely going to owe him some damages. Okay, real quick summary here on our negligence unit. I know we've covered a lot of ground here over the last 2 weeks, but there are a couple things I want you to take away. First of all, I want you to keep in mind where negligence falls on that tort law spectrum that we looked at on that first day of lesson. So remember that in terms of the different types of torts we're going to look at this semester, negligence definitely falls on the lower end of the spectrum, meaning that it's the least severe of all of the tort laws we're going to look at. Remember, with negligence, there's really no intent to act and no intent to harm, basically just some careless action or inaction that occurred. Another big takeaway here is those 4 elements of negligence. you're definitely going to want to make sure you understand those 4 elements and how to actually apply them to a case. Obviously, you got some practice last week with the case study. Make sure that you grasp that, because you are likely going to have to do that again, probably on an exam. So make sure that you understand those 4 elements and how to actually apply them to a negligence case. Finally, it's important that you have a good understanding of the potential negligence lawsuits that can occur for K&R practitioners, and we've just done kind of a brief lesson into those potential settings today. And then I want you to think about this from the perspective of the practitioner, right? How could you, as a practitioner in the field of K&R, protect yourself in a negligence claim? In our last lecture series, went over a number of potential defenses available to you as K&R practitioners. So, essentially, it's not just important that we understand these cases from the perspective of the plaintiff, but that we understand how we might be able to protect ourselves from the perspective of the defendant. Because unfortunately, if you are to be involved in a negligence lawsuit, most likely it will be in the role as the defendant or on behalf of your organization.